All right, hello everyone. I see folks trickling in, so I'm just going to give everybody maybe a minute or two before we start. I know we were meant to start at 12, but I want to respect your time as well. So let's wait maybe another 2 minutes, give people some time to join, and then we will get started. Thank you. All right, let's get started. We can, for anybody that's joining later, hopefully you can get caught up based on the questions. I will ask for you to please send any questions you have via the chat function as we're going through the slides, because then Eileen and I can answer them. We will leave time for questions at the end, but if there's anything pressing that you want addressed as we are going through the slides, feel free to ask us then. For those of you that may not have joined us previously for one of our sessions, my name is Kripa Upadhyay. I am an attorney here at the Buckhalter office in Seattle, Washington. Joining me for this presentation is Eileen Duprat. She is special counsel or an associate here at the firm, also on my team. Our practice is primarily corporate and investor-based immigration. And within that, Eileen handles a lot of H's and L's and O1 visas. I handle mainly investor and exceptional ability petitions, so a lot of national interest waivers, EB1s, EB5s. My practice is a little more different because I also handle issues relevant to international trade and immigration, and also increasingly labor and employment law, particularly in the context of ongoing worksite raids, which we will cover in this seminar because that is something that you as either employers or attorneys advising employers need to know about. Worksite raids and I-9 audits are very much back in full force under this administration, and that's something you need to know about. So let's get started. With respect to where we are, the current state of U.S. immigration, here we go. Scream. This is literally what I feel like every morning, just because there's so much happening. There's just so much happening. So this is what I feel like we are going through. But where we are is also, I'm so sorry, I have no idea what's happening with my screen here. Where we are is also essentially a re-emergence of what happened during what I call Trump 1.0, right? So the first half of the first term of the Trump administration, 2016 to 2020. Some of the things that happened then are making a comeback. We don't yet have travel bans, but we definitely have the actions specifically targeting H-1B visa holders that have made a comeback. As of now, there is no suspension of premium processing, which did happen in 2017, but there are already changes afoot at USCIS such that there will be changes in terms of minimum qualifications required for specialty knowledge positions, and then also significant changes, particularly for companies that are considered to be consulting companies, or companies that derisively rather are referred to as job shop, right? So you don't have a product or a service of your own, but you have employees, and they are your product or service, if you will. Your talent, your resource is what it is that you're marketing. So that is very much, again, the consulting company model is very much, again, under attack, or at least under the spotlight. And so for those of you that are consulting companies that sponsor people on H-1Bs or even L-1s as consulting companies, we're going to talk specifically about what you need to be aware of. But the thing that has come back, which affects you as employers and attorneys advising employers, is this concept of extreme vetting, right? We saw this 2016 to 2020. What extreme vetting basically means is USCIS is no longer going to give deference to cases that they decided previously. So let's say you applied for an H-1B 2006, it was renewed, you applied for it again, sometime in the 2010s, that was renewed, you're currently on your third or fourth extension, and all of a sudden now you're probably looking at a request for evidence, which is very onerous, asking for everything in the kitchen sink that you've already provided over the last 3 or 4 years. Also not unusual to see denials at this stage from immigration, and that's because under the extreme vetting standard, they are looking at every single line of every single page and not giving deference, not giving any respect, if you will, to prior decisions by other officers. Extreme vetting is also playing out at the consulates. So just in the last month, obviously we've only had the administration in place for about a little over a month now, but in that time we have already seen the revocation or rescission of what we used to call Dropbox appointments, right? So if you are somebody that had an H-1B previously granted to you and you have a stamp on your passport which is H-1B stamp, and you got that at least 24 months ago, you did not then have to go for an interview, right? You could just drop off your passport, they would stamp the passport, and you would collect it via a courier service. That is no longer the case. Dropbox no longer exists. If your H-1B or any visa stamp that you received is older than 12 months, or if you previously received, let's say, a tourist visa or a student visa or an L1 and you are now applying for H-1B, Dropbox no longer is available to you. You have to go in for an interview. And that's where extreme vetting is going to come in. We're going to talk about 221G, which is the administrative processing that is currently playing out at consulates, particularly Mission India, Australia. And we're also hearing some of this coming out of Mexico. But we're going to talk about what 221G means, because for you as employers, as HR managers, that means at its best that you have to be prepared to have your employee be stuck outside of the US for anywhere between 3 weeks more than you expected to 6 months more than you expected, right? So there are going to be disruptions in workforce. Okay, so for those of you that may be new to H-1B, the basic eligibility criteria for H-1B is that the employee must qualify as a specialized knowledge employee, which means that they have to have at least a US bachelor's degree or a foreign degree, which is evaluated to be the equivalent of a US bachelor's degree, right? And it is not that the candidate has a bachelor's degree, but rather that the work that they are doing, the job that they are doing, is complex enough that it requires a bachelor's degree as a minimum for entry into the profession. So, for example, if you are a foreign trained nurse and you have a registered nursing degree, most people in the US would consider that to be specialized knowledge because it's so technical, right? But according to the US government, you do not have to have a bachelor's degree in order to get an RN degree. You could go from high school to an RN. Therefore, RNs, registered nurses, generally speaking, do not qualify for a bachelor's degree. Right? So for those of you that may be new to the program, if you're looking for somebody that's, let's say you have a restaurant, because I get this quite often, if you have a restaurant and you're looking for somebody to come in as your front of house manager, unless that person has a degree in hotel management or hospitality management or master's in business or some such related function, you cannot hire somebody to be front of house unless the job description that you have for that person is complex enough that at minimum the requirement across the industry is that they have a bachelor's degree. Okay. The other thing to understand is that these visas are valid for 3 years with a 6-year lifetime max, meaning that an employee on an H-1B cannot be on H-1B beyond 6 years unless there is a petition for immigrant visa filed for that employee. So typically you would get an H-1B for 3 years, and then you would be able to get an additional extension for 6 years. Extensions beyond the 6 years are contingent on there being what's called an I-140, which is the immigrant petition for alien worker available to that employee. But otherwise, it is a 6-year lifetime cap. The other thing to deal with if you are new to the H-1B system is that generally it is a cap on visas, meaning there is a limit to how many H-1B visas are available in any fiscal year. The immigration system fiscal year starts October 1st and ends September 30th of the following year. Right. So currently, if you're confused about why we're talking about fiscal year 2026, that's why, because the jobs can only start October 1, which is at the end of this current fiscal year. Right. So there are 85,000 visas available for H-1B. Out of those 85,000, there are 20 that are reserved for candidates that have a master's degree in the US or higher from an accredited university. So it cannot be a master's degree from a for-profit school. It has to be a master's degree from an accredited nonprofit educational institution or a PhD, and you have 20,000 reserved for that pool of candidates. Otherwise, it is 65,000 for what we call the general cap. And the general cap includes individuals that have a bachelor's degree from the United States or a foreign earned degree that is evaluated to be the equivalent of a bachelor's degree, or they have no formal education, but they have significant years of experience, and you can get a evaluation saying, for example, 13 years of progressive work experience is the equivalent of a bachelor's degree. It's not unusual to find the work equivalency in some tech industries or in some tech fields, right? Because it wasn't always necessary for you to have a bachelor's in computer science. You could learn to do coding without having to go to school. And so, depending on what industry you are in, it is possible to get a bachelor's, to get an H-1B without having a bachelor's degree, provided you have sufficient work experience. Now, outside of the 85,000, there is something called cap-exempt, which are entities or employers that qualify to bring on H-1B employees without having them go through the cap. This historically was restricted to nonprofit institutions affiliated with accredited universities or research institutions, right? And the research had to be the fundamental part of that work, of that entity's work. That has now changed, and we'll talk about the changes. So these changes came up. The expansion of what a cap-exempt organization is came about because of the outgoing Biden administration's law called H-1B Competitiveness Act, which was introduced, I believe, December. So it was literally in the last 30 to 45 days of the Biden administration that we received this new law. But we'll talk about what that change is and how you might be able to benefit from it as an employer, because you may have the option of getting cap-exempt H-1Bs. So the H-1B registration window is very, very quickly approaching. For this year, it opens March 7 at noon Eastern, closes March 24, noon Eastern. What does registration mean? It basically means if you are a new employer, you're new to this H-1B filing system, then you have to register yourself. You have to have an account at uscis.gov as an employer where you would register the entity. So that means providing information about the name of the entity, your FEIN number, the number of employees, all of that stuff. And then you can do that prior to March 7th. March 7th at noon is when you need to start registering individual employees. And there's some information that you will need to provide about your employees. You don't need to provide information about financials of the company right now. You don't need to provide any support of on available work or ability to pay the employee right now. The only thing that needs to go in for the employee is their personal information along with a valid passport. The passport does need to be valid for at least 6 months. Otherwise, we're going to have an issue if the registration information has a different passport number than the selection information, we're going to have an issue. So to the extent possible, make sure your employees have passports that are valid for at least 6 months. Then at the time of registration, you have to also select whether the beneficiary is being put into the master's cap, which is if they have a master's or higher from the United States, or the regular cap. The reason that there is that distinction between master's and regular is because the way that immigration runs the lottery is all candidates with a master's or higher from the US will be put through the lottery first. They will select 20,000 eligible registrations. Anybody else above the 20,000 then gets pulled out of the master's lottery and added back into the general cap lottery. So essentially, candidates with a master's or higher get 2 shots at the lottery, right? But that's how it works. So which is why you want to make sure you have that designation correct. So here we go to the significant changes under the Biden administration plan. One is revising the definition of what is a specialty occupation. So the new rules clarify that an employer may accept a range of qualifying degrees or fields for the H-1B position, but that has to be logically connected to the duties of the position. Now, you will see this generally in terms of, let's say, for example, AI machine learning degrees, because AI machine learning work, because it's now you may be able to get, an engineering degree with a special focus on AI or a special focus on machine learning. But for the most part, that was not available even as recently as 4 years ago. And so if you're saying this degree is for somebody that needs to do effectively training models for AI, but they have a degree in engineering or they have a degree in math, then as long as you can make that logical connection between why the engineering degree or a degree in math is acceptable or is needed or is crucial to somebody that is doing AI modeling, that's up to the employer to decide, right? It's up to you to make that decision, to be able to meet that burden of proof, basically. It's your requirement to show why that makes sense for you as an employer. With respect to the expanded opportunities for cap exempt, many nonprofits and government organizations are exempt from the cap and are able to submit requests for visas that do not come within that 80,000 limit. Originally, like I said, it used to be that they would be eligible for research if you could show that the research was a fundamental activity of the entity. That has now been changed under the Biden administration plan, rather than the previous definition, which considered it exempt if they were primarily engaged in research, and research was a fundamental aspect of their work. All they need to show now is that primary mission involved research, right? So research is a part of the work that they do. It is not a fundamental or a crucial or the only part of the work for that entity. So hopefully more entities will qualify under cap exempt. If you have questions about whether you qualify as a potential cap exempt employer, please feel free to contact me. Eileen and I would be happy to make that assessment and get back to you with a definitive answer. Other significant changes under the Biden administration plan is, for the first time, we are now able to legally register the entity and the employee where an employee essentially owns the entity. You could be a single member LLC. You can be the sole owner of company ABC and also petition for yourself under the new H-1B rules. You do have to be able to show that there is a bona fide employer-employee relationship. We've done this even prior to the change, and the way that we did this is essentially what they're asking us to do now. So we were very prescient about being able to do this early and being creative within the laws. But what we've done historically, and we've had success with this, is by getting clients to constitute essentially an independent board of 3 to 5 people or an independent employment evaluation committee. And that committee or that board then has complete, unfettered, 100% independent rights to evaluate the employee slash CEO founder and to set his or her salary and performance metrics, right? So there is still some degree of accountability, but that is what happens. Um, Sorry, I'm getting a message saying, "Are you sharing your screen?" I thought I was. Not quite sure why you're not able to see it. Give me a second. Let me see if I can do this again. Right, sorry, give me just one moment. I'm going to try and figure out why you're not able to see my screen. I thought we were sharing it. Right, you should be able to see it now, hopefully. Don't think you should have any problems. Um, right, so let me go back to where we were. Okay, so here we were,
Huh?
regarding bona fide employer-employee
It went
relation.
away. The slide went away again, so we don't see it anymore.
Ah, that's weird because it does say I'm sharing my screen. Hmm. Right, can you see it now?
Not yet.
What is happening? Right, okay, I'm so sorry. I don't know why we're having technical glitches. I might have to just share slides later after the
Now it shows.
presentation.
Now it shows.
Now it shows.
Oh,
Okay,
yeah.
this is just strange. All right. Okay. So back to where we were with respect to the expanded opportunities for cap exempt. Then the next is significant changes also include student visa expansion. So one of the changes historically, one of the issues historically has been that students that are on F1 generally will finish school or graduate sometime in June. The problem, if you will, with an H-1B is if you are going through the cap exempt process, you're doing that process in April, you're filing the application in chief sometime in June, but if it is approved, you cannot actually start working on the H-1B until the 1st of October. Now, if you have students that are employed at your facilities and they are either on OPT or cap, STEM extension, and that STEM extension carries them through, then great. They can continue on that work permit up till September 30th, and then October 1, status would effectively change over immediately to H-1B. But there's always been what we call a cap gap, right? There's a gap in terms of employment when the employment starts on H-1B and when their student visa ends. And so under the Biden administration rule, students that have work authorization but would be facing a gap in terms of residency in the US and status in the US are now able to go back to their universities, work with their designated student officers, and get an extension on the I-20. The I-20 is the student visa that determines how long they can stay in the US on a student visa. They can go in and get an extension on the I-20, provided they are selected in the cap. Right. Okay. Significant changes also include program integrity. I'm going to talk about this a little bit more. Stricter workplace scrutiny. So that is true across the board, right? Workplace scrutiny goes hand in hand right now with worksite enforcement, which includes fraud detection, national security agents basically showing up at your workplace. It includes I-9 audits, which we are already seeing a significant spike on I-9 audits. So those two things go hand in hand. There is also meant to be easier extensions, at least that is what was proposed under the Biden administration plan, where immigration officers both at USCIS, which is within the US, and consulates abroad were going to give deference. They were going to listen to decisions that were made by their colleagues on prior petitions. Problem is, we now, as I said earlier, are back to the Trump era policies of extreme vetting, which does not allow for deference. So even though this was called for at the December policy, which is now law under the Biden administration plan, the extreme vetting is in direct conflict with this provision of the H-1B Competitiveness Act. Focus on program integrity basically is going to play out in two ways. Like I said, we'll talk about FDNS requirements later, but going back to what I said earlier about the H-1B lottery, the reason you need to be careful about this, or you want to pay attention to this is something that, again, we went through rather with the Trump administration's first term, which is, like I said, the employee must possess either a bachelor's degree from an accredited U.S. university or a foreign degree that is deemed to be the equivalent of a bachelor's degree. And then the bachelor's degree has to be in a relevant field, right? The reason why I am coming back to this right now is that, let's say, for example, you file an H-1B this term, whether you are doing a cap H-1B or whether you're just filing for an extension, be prepared to receive an RFE from USCIS that challenges whether the degree is relevant. And we're seeing a significant spike in request for evidence from the government, even in cases where it was just a simple extension, if you will. So this is something that is priority in terms of what the current administration is looking at and what they are challenging. And so if you have a candidate that has, let's say, a degree in aerospace engineering or aeronautical engineering, and that is not the immediate work that they are doing, expect to receive a request for evidence challenging why and how they are eligible for this particular job function, unless it involves some form of aeronautical aerospace engineering principles. Okay, so for IT consulting companies in particular, there is going to be significant scrutiny in terms of your petitions and what you are filing and who you are filing with, particularly if you are filing for candidates that are not going to be placed at your physical location, but are going to be placed at a different work site. If that different work site is in a different state, expect significant blowback and pushback from the government. So, for example, if you have your business is in Washington State, but your employee is going to be based in Texas, the request for evidence and the challenge from the government is going to be, how do you continue to supervise and control this employee? Right? The H-1B rules require ongoing employer-employee relationship. And so if your employee is clear across the country in a different state, the government is going to want to know, how do you continue to monitor this employee's work? How do you monitor their comings and their goings? What are the systems and processes you have in place to be able to exercise control? So again, going back to 2016 to 2020, because, God help me, I was doing this even back then, you just have to get creative. And that means for you, do you have some sort of an internal system where the employee clocks in, clocks out? Do you have weekly Zoom meetings? Do you have some sort of a system like a ShareFile or Dropbox or whatever else that you are using where you can monitor projects, ongoing projects that the employee is working on? Do you have periodic feedback sessions? Are you coordinating with a manager or supervisor at that offsite location to get feedback on your employees' performance, right? That's the other thing that you could do. So those are things you're going to have to be prepared to answer. It used to be under the Biden administration that if you had consulting companies typically function based on short-term contracts, right? Some of these could be as little as 6 months, but anywhere between 6 months to a year. It was not the case, at least under the Biden administration, that we had to provide evidence of there being enough work if we were asking for the full 3-year term. That is no longer the case. Immigration now will increasingly revert back to Trump 1.0 policies from 2016 to 2020, where they will only approve the H-1B for the amount of time that you can show that there is available work, because that is also one of the criteria for H-1B. And so if you have a history with a particular company and you have repeatedly received renewals on your contracts. This is again specifically for consulting companies. If you have received renewals of contracts with that same company over the last 5, 6 years, then be prepared to provide historical data to show that historically you've always gotten approvals and there's no reason to expect that things would change this year. But the takeaway is for consulting companies, you're going to need to be prepared for more requests for evidence. But before you get to the request for evidence phase, you're also going to need to be prepared to provide a lot more documentation to attorneys than you probably have been used to, accustomed to during the last four years. Okay. Um, Again, connected to immigration companies and well, consulting companies and what we're seeing, be careful about speculative future work. So Nanosemantics Inc. is a visa fraud case that is currently making its way through the federal district court in California. This is a case out of San Jose. And what they essentially did was, and there was fraud in this, but it was essentially prospective work that they were guessing they would be able to get. But they were filing H-1Bs without having ready work available. And it was three individuals who were basically came together to provide letters in support of H-1B applications, saying that there was future work available, when in fact there wasn't. That has now resulted in investigation and charges against all three. All three people have pled guilty. Sentencing is due. Each of them is facing something like 10 years in prison and a $250,000 fine per charge, and there are multiple charges. So be very careful about speculative future work. If you expect to get it, if you're in conversation with companies, that's fine. But to just be like, well, it's sort of created out of whole cloth and out of thin air, that would not be very beneficial to you. Um, Select consular posts, again, I think I talked about this earlier. Mission India, Mission Australia, and to some extent we're hearing about some of the consulates in Central America and Mexico are no longer allowing for Dropbox eligibility. I believe this is true also now of London as of last week. No longer allowing for Dropbox eligibility, which means that, again, as HR owners, managers, you need to be prepared to have your employees essentially be out of the United States for as long as 3 months, 3 weeks to 3 months. Dropbox not being eligible for Dropbox basically means employees that previously had an H-1B visa and are now just applying for a renewal. But if that H-1B visa was given to them more than 12 months ago, they now need to go in for an interview. The reason that this becomes an issue is because the interview is a precursor to what's called a 221G administrative processing. And that 221G administrative processing is a very dark, very deep black hole, which none of us as attorneys has been able to figure out, right? Once it goes into 221G processing, it may be simple as your fingerprints haven't cleared, we need 3 more days to clear your fingerprints, and then they'll call you back and your visa is ready. Otherwise, it could be, we need to look into this a little more. Okay. What documentation do you need? Can my employer or I provide you specific documents that you need? No, we'll tell you when it's done, right? What are you reviewing? We'll tell you when we're done reviewing. So you're going to be faced with no answers and an employee that's likely going to be stuck outside the US, like I said, anywhere between 3 days to 3 weeks. This is going to apply to any of your employees that are currently outside the US and are seeking to enter the US the first time on an H-1B visa, or any of your employees that were on F-1 student visas and they now are going to be converting to H-1Bs, or any employees that had an H-1, but that stamp is more than 12 months old, and so when they go back to the home country or leave the United States, they have to get a new stamp and come back in, right? This is who it's going to affect the most. Right. Now, I don't know how many of you, deal with L1A and L1B, but L1s, for those of you, if you're interested in knowing, L1 is available to employees of multinational companies. So if you have an entity in the US and you have either an affiliate or a parent or a subsidiary outside of the US, and your employee has been working with the foreign subsidiary for at least 365 days, they are eligible to come in either as an executive or a manager, which is the L1A, or specialized knowledge employee, which is the L1B. Your specialized knowledge L1B is analogous to the H1, but you don't have to go through the lottery because it's a separate visa class, but they function the same. The adjudication requirements, right? So the requirements that USCIS officers or consular officers are looking at for L1B specialized knowledge employees and H1B employees is effectively the same, with the added distinction for L1B employees of you best practice advice here is for you to be able to articulate why do you need this employee in particular? Why can you not hire somebody in the United States and train them to do the work that this person does, right? And so if the answer is basically this is not something we can train within a 3 to 6 month timeline, this is something that this person has spent 2 to 3 years working on, honing their skills on, training somebody to have that level of institutional knowledge and skill would cause significant financial losses for you, then you may be able to get an L1B through relatively quickly. But these do not have to be subject to a lottery. But there are separate criteria in terms of adjudicating these cases that you need to be aware of. Okay. Enhanced fraud checks for employers. So again, like I said, one of the main things coming out of the Biden administration in the December codification of H-1B competitiveness, as well as current administration policies, the focus is on eliminating or combating alleged fraud in the system. Now, this is not my politics coming through, this is facts. There have not been as many cases of fraud in the H-1B employer system as the government would like for us to believe. Have there been cases? Yes. Is it as rampant as everybody claims it to be? No. There's just not enough data to support that contention. But for employers, what you need to be prepared for is increased enhanced checks for employers as well as employees, right? So the things that are going to happen is, again, as a part of the extreme vetting and the interview process, whether that's in the United States or at consulates, expect your employees to be questioned about what is your job title? Explain to me a typical workday. Where will you be working? What is the address of the location where you will be working? Who is your supervisor? Who is your manager? Who is your supervisor's boss? What is the pay that you have been offered? Are you offered part-time? Are you offered PTO? Are you offered sick leave? Is there any benching? So for those of you, again, that are new to H-1B, you cannot bench or furlough H-1B employees, meaning that they cannot be forced into unproductive time, right? And so it's common for officers at the consulates to question them about whether there have been any periods in time where they have been asked to take time off or where they have been told forcibly to take a day off a week, which is unpaid because that constitutes furlough. So in terms of enhanced fraud checks, be prepared for your employees to be asked these questions. There is also an FDNS site inspection process that immigration officers will follow, which sort of tracks these issues that are highlighted in this slide, but I'll talk about the FDNS portion in a bit. Again, for those of you that are employers that are bringing in employees on temporary B1 visitor for work visas, be very, very careful about how those are structured. There have been multiple cases where the US government has actually filed charges against significant companies for conspiracy to commit visa fraud. And most of those cases have been with respect to the use of B1 visas as a way to get around the H-1B and the L-1 processing timelines and all of that. So a B1 visa is a type of visa that allows employees to come into the United States to receive training, to give training, to be a part of contract negotiations, or to attend conferences. It is not meant for employees to come into the US and do actual active work, right? And they're meant to be short term, as in a week, a month, 3 months if you really want to push it, but not more than that. Recent list of companies that have faced significant fines, like I said, is April 21, 2023, record $9.9 million fine against Larsen and Turbo. August 4th, 2023, Shai Cohen is currently, I believe, sentencing has already been completed, and I believe they got the maximum sentence, which is 20 years in prison, for multiple cases, multiple fraud charges. And then September 19, 2019, $2.5 million fine against Mu Sigma. And now Mu Sigma and Larsen and Turbo are both companies which I believe have now been blacklisted by USCIS, meaning that they can no longer bring employees on B1 visa. I think that is what part of the final settlement was. But yeah, a $9.9 million fine was a record for for B1 visa violations. Right. So hopefully you don't go through this, but to the extent that you do, understand that having employees on an H-1B also means that there are certain requirements that the employee has to meet, right? So if there is a separation from work, a forced separation, termination from work, that employee has 60 days from the last date worked. Do not count severance pay. It's just last date of active work. 60 days from that point forward to either find a new employer, change visa status, or to pack up and leave the US, right? So it's 60 days and that's it. That's not an extension that you get. L1 employees cannot change employers because the qualifying requirement for L1s is that they have worked with a foreign subsidiary, affiliate, or parent for a minimum of 365 days in the last 3 years, at least 1 year within the last 3 years. And so they're not able to just switch to a different employer. In the event that you have a mass layoff at your company and you have ongoing immigrant visa applications or perm processing cases, understand that that is going to be negatively impacted. Anytime there is a mass layoff and you have a perm process ongoing, Department of Labor is going to want to see some evidence from you that you have made an effort to identify U.S. national or lawful permanent resident employees that were affected by the layoffs, and to the extent that they qualify for this position, that you have offered them this position, that they have declined, and then only can you go forward with the application for a foreign national employee, right? So significant changes afoot and significant requirements for you. I've gone through the extreme vetting slide already, talked about it several times, so we'll skip that one. The other thing that I want to talk about is to be prepared for possible disruptions in your workforce. Now, this is outside of the H1. This is likely going to affect H4 EADs, anybody on DACA, anybody on TPS or temporary protected status. As things stand, TPS for Venezuela has already been declared as not being eligible for renewal. It was meant to be renewed April, and that is not happening. So that's potentially 65,000 Venezuelanos that are going to be out of work authorization and out of legal status. So to the extent that you have people from Venezuela that are a part of your workforce that are working under EAD or an employment authorization document, you need to start making arrangements for what comes next. Same thing for Haiti. Haitians were also eligible for work permits under TPS or temporary protected status, which is basically humanitarian relief for people fleeing climate conditions, war, famine, any of that. The work authorization or temporary protected status for Haiti apparently is also no longer going to be renewed. And that has, I believe, somewhere in excess of 100,000 individuals currently in the United States that are Haitian and that are working under EADs. Similarly, for DACA, Trump administration during Trump 1.0 basically stopped DACA, and so everybody that is currently working under DACA candidates or DACA eligible people that are currently on DACA is because they had DACA before it was rescinded. They are allowed to renew DACA, but there are no longer new applications allowed for DACA. We expect that DACA at some point will be terminated. So expect to have essentially significant impacts on your workforce that is working contingent on different visas. The one that I am most concerned about, honestly, is the H4 EADs for spouses of people on H1Bs. This is a federal lawsuit that I was involved in. I was one of the attorneys that filed this in federal court, so it is very much a labor of love for those of us that were a part of it. Unfortunately, settlement agreement for us with USCIS was that there would be a sunset, meaning that the program would end at some point in 2025, and it was up to USCIS to extend the benefit. As of now, we have not received anything saying that they plan to extend it. I don't believe there is an option for us to go back to court and refile a new lawsuit, although that may be what happens. But heading into the end of 2025, we may, at worst, lose H4 EAD. So again, there is going to be a significant disruption for workforce. Okay, sorry, I was just checking in on the chats to make sure I wasn't missing anything. All right. So again, we've talked about TPS extensions for Venezuelanos. I also added information that came in 2 weeks ago about TPS rescission or revocation for folks from Haiti. The other thing that all of you need to know about as employers, as attorneys advising employers and in HR is that compliance is crucial. Like I said, we're already seeing record number of notice of inspections being sent for I-9 audits. If you have not previously done an I-9 audit, I urge you to contact us. We've been doing them significantly busy actually with I-9 audits now, and we've been doing this for a few years. I've been writing about I-9 audits and the need to make sure you're in compliance since I think October. So there's several articles on the Buchalter website if you want to look at that. But this is something that should be telling, right? This is something that should give you a sense of what to expect. This is for the first Trump administration. So from 2017 to 2018, there was almost a threefold increase in the number of notice of inspections that were sent out, significant increase in the number of I-9 audits, significant increase in the number of criminal arrests based on not completed I-9s or falsely helping undocumented folks continue to work, or employers essentially turning a blind eye towards employees that they knew or should have known did not have work authorization. So I-9 fines have continued to increase. We are currently at, I believe, $2,500 per error per form, right? And if you're looking at 25, if you have 3 errors on your form and those are substantive errors, and you can be charged the full fee of 2,500 for each of those substantive errors, 3 errors per form for an employer that has 50 employees, looking at potential bankruptcy at that point, right? There is a way to obviously not have it get that far, which is do your I-9 audits now, preferably with an outside attorney. And that, again, that's not because, I wanted to guarantee employment for my peers. It is because having an independently conducted I-9 audit helps you in the mitigation phase. So if immigration comes in, conducts an I-9 audit, they find significant errors, you saying we off our own will hired an outside attorney. They went through this, they marked the errors for us. We are following the processes that they gave us, so we will not have the same mistakes. Means you will likely get the benefit of not having to go through another audit for at least a year. And then immigration officers will come back and make sure that you actually learned from those mistakes. Alongside that is also mitigation. You can ask for lowering of your fines if you can show a good faith effort to stay in compliance or get in compliance. So again, compliance is crucial moving forward for employers. Again, statistics from the 2016 to 2020 term, so you can see exactly what those numbers were, but HSI is Homeland Security Investigations. It is a part of USCIS. They are the ones that essentially conduct I-9 audits. But they opened 6,093 worksite investigations in under a year, from 2017 to 2018. 6,093 worksite investigations, 675 criminal and 984 administrative work-related audits. initiated 1,360 I-9 audits, again, in fiscal year 2017. And that period was literally October 2016 to September 2017. So just in the span of a year, or a little less than a year, 1,360 I-9 audits, which honestly, if you look at the historical data for HSI, 2012 to 2014, they probably did 1,360 that entire term, right? We're talking about a year over here. So again, compliance is crucial. You cannot afford to sit back on this one. And this FDNS is very, very important for those of you that have employees on H-1B. So an FDNS site inspection primarily aims to check for potential fraud in employment verification. The role of an FDNS officer, and FDNS officers are also going to be USCIS officers. HSI are also going to be USCIS officers. But what an FDNS audit does is an investigator or an officer from the Department of Homeland Security will contact either you or your employee. They can contact your employee directly. And what they are going to want to do is sit down and speak to your employee and ask that employee, what is your job title? What location do you work at? How much are you paid per week? How much are you paid per year? And at that point, what they are looking to do is essentially ensure that the information you put into your labor condition application and your H-1B application, saying this is where my employee is going to work, this is the work description, this is the work location, this is how much I'm paying him or her, that that information is actually true. And that is actually what you are doing, right? The thing with FDNS site inspections pre-December 2024 is that they were voluntary. A lot of employers, rightfully so, didn't think that they had the option of saying no, but legally at least it was voluntary. But under the H-1B Competitiveness Act, which now again became law in December, proposed by the outgoing Biden administration, it is no longer voluntary. It is mandatory. You have to comply. You have to agree to an FDNS inspection. So again, making sure that you and your employee understand what your roles are, what your responsibilities are, what is it that the person is looking for is extremely crucial moving forward, right? I know I sound like a broken record, but I cannot emphasize enough how key compliance is, because again, if you are found to be in violation of H-1B, understand that that means revocation of the H-1B for your employee, which leaves them at risk of deportation and removal. But it also means if USCIS thinks that the offenses are egregious enough, it means blacklisting you from the program, which means you will not be able to file an H-1B ever until you come off of that list, right? So I'm not just saying this to get you guys worried or to, like I said, ensure employment numbers for my peers, but this is significantly crucial. And again, judging from 2016 to 2020, the first Trump administration, we're already seeing this play out just in the first couple of weeks of this second administration, right? It's also important for y'all to understand the difference between an FDNS inspection versus an I-9 inspection versus a worksite raid. All three of those have already started, right? Those FDNS inspections have started. I-9 audits are already, I think, at an all-time high compared to where we were last year. And worksite raids have already started, and I'm sure you've read about it in the papers. But what is the difference between them? So again, FDNS is the Fraud Detection National Security Directorate. These are going to be unannounced visits, right? So someone's going to show up at your door, tell you they're a USCIS officer and want to sit down and speak to you and your employee. Now, at these visits, they can and very well may ask or demand to look at your public access folders. So for those of you that are H-1B employers, you're meant to keep a public access folder for each one of your employees. They may also want and demand to see I-9 documents for that specific employee. And you're going to have to provide it to them, which again, from a compliance perspective, means you need to have a very thorough document management system, right? Because you cannot have personal identifying information in the I-9 form. So let's say employee reviews, employee home addresses, things like that, don't need to be in an I-9 app, in an I-9 folder, and what's in an I-9 folder should not be in your public access folder. So you need to have a proper document managing system that keeps things separate. So if FDNS comes in, you know what they get access to. If I-9 audit is happening, you know how to handle that. So again, FDNS audits are going to be unannounced. You are required to cooperate. This is unusual. We haven't seen too much of this. We did see it under the last administration, but the government is taking a much more hardline stance against employers that they believe are knowingly or repeatedly flouting the laws, right? And so we do have False Claim Act case that was raised against certain companies. And the False Claim Act basically means, like I said, knowingly hiring somebody that is not authorized to work, or knowingly turning a blind eye and saying, well, I didn't know, when there was enough reason for you to know, or you should have known that that person did not have authorization to work. In very rare cases, we have also had RICO charge, which is federal charges against employers for essentially encouraging illegal immigration, employing illegal immigrants, and harboring them, meaning that helping them, you know, complete false I-9s, or helping them somehow hide the fact of their truth, which is that unfortunately they are undocumented or that they did not have work authorization. So you want to be really, really careful about this. Steps for employers, like I said, it's important to have an immigration plan. I'm a very, very big believer of immigration plans, as well as immigration enforcement readiness plans. Those are two separate things. An immigration plan is, who is your current workforce made up of? What nationalities are they? How many of them are on H-1B? How many of them are on L-1? The reason you want to start doing that is because at some point there is a distinction about when does an H-1B employer become an H-1B dependent company, because then your onboarding, your hiring has to change in order to account for you being a company where at least 50% or more of your workforce is on H-1Bs or L-1s, right? Because then there are additional steps you have to take towards recruitment to make sure that you're not unfavorably discriminating against U.S. citizens or U.S. qualified employees. So you need to have an immigration plan, which helps you understand bird's eye view of who your employment workforce is. Because again, tomorrow, let's say, the rule comes out saying anybody that is on an H4 is no longer authorized to work, you're going to need to start terminating those people and then recording the date of termination on the I-9, right? So you need to understand how to do this and to be systematic about it so you're not facing liabilities. Again, independent I-9 audits, I think we already talked about it. You need to do this. There's no other way for me to say it. Do it now, do it properly. Intentional hiring, again, do not file H-1B applications or L-1B applications or any applications with the expectation of having work at a later date. That's probably going to head more into the fraud category, and you're going to face criminal liabilities for that. Again, PERM is the immigrant visa application process. My recommendation, again, tied to the immigration plan, is what is the country of birth of your employees and which of those employees is crucial to your entity. Because if you have employees that are born in India or China, you're looking at significant wait times for green cards based on employment sponsorship. But you are also looking at significant wait times just to get to that part where you are able to file an I-140 petition, which is the immigrant petition for alien workers. Once that I-140 is approved, then your H-1B workers can continue beyond 6 years and get 3-year, year-over-year extensions. But just completing the perm process right now is close to 24 months, right? And so again, back to the immigration plan. If you have an employee on an H-1B who can only be here for 6 years, and it's taking us at least 24 months to just complete the perm process, you really need to start that perm process year 2, year 3 at the absolute latest, right? But unless you have that written out somewhere, you have some sort of a tickler system, you're going to miss it. So that's why I keep harping about that, if you will. Okay, these are some resources that are available. This is all available on the website on buckhalter.com. But like I said, I've been writing articles, I've been speaking, I've been conducting trainings on worksite enforcement, FDNS inspections, I-9 audits, how to do them correctly. And so much of that is in these articles. And you can find this under my profile on the website for Buckhalter. You can also find, I think, links to prior webinars that we've done on worksite inspections and I-9 audits. But
One question.
that's, yeah, sorry. So
Yeah,
that's all we have for prepared comments. But as I said, I wanted to make sure we left enough time for questions. So I'm going to leave it at this slide just so you have my phone number and email, but more than happy to answer questions that you may have.
one question.
Yes.
Oh, there's more coming, but um, one of the employer was asking if all these H-1B or H-4EAD TPS, will that apply to TN visa categories?
No, so TN is part of the USMCA trade agreement, which is specific to Canada and Mexico. It is a tripartite agreement. So TN is a different category. It's only available to citizens of Canada and Mexico. It does not include H4 or TPS or anything. If, and again, this is not my politics, this is a fact. If this commentary about Canada becoming the 51st state and tariff wars and trade wars against Canada and Mexico continue, the absolute worst case situation is that those two countries may decide to opt out of USMCA, at which point TN goes away. Because the TN visa is a part of that tripartite trade agreement. But otherwise, no, it won't be an issue. Okay, OTP candidates, I assume you mean OPT, but okay, lots of master's degrees are looking for help and you have interesting work. It could be sporadic, okay? Um, those students are going to have to work with their designated student officer. You can do a part-time OPT. You can do a part-time STEM OPT, but that means they can only work 20 hours a week. Can an H-1B worker work out of a home office or do they absolutely need an office space? Well, again, the issue with working out of a home office permanently is how is the ongoing supervision for that employee, right? You can do a remote situation, but most remote, even now, is at least 2 days in the office. So can you have an employee who is working from home a full 40 hours a week without any supervision as such? You're likely going to run into a challenge from immigration saying there isn't enough of an employer-employee relationship in that situation. So I would say that's best avoided. The other thing that you absolutely need to avoid, and I see this again, um, just going to put this out there. I see this with smaller employers where employees think they can benefit either by, I don't know, guilt tripping the employer or threatening to quit or some such combination where the employee says, I'm going to work remotely from my home country, right? And then they leave to the home country and stay there 3 to 4 months, allegedly while still continuing on their H-1B. Do not do that under any circumstances. Please do not do that unless your employee can provide significant documentation of bereavement or significant emergency for a family member where they need to be on the ground to help care for a family member. It is not feasible, it is not reasonable to expect USCIS to turn a blind eye to that. Because think of it, as an employer, you are bringing this employee into the United States because you're saying you need their skills and their talent in the US, right? But if this employee is able to do that skilled work without needing to be physically present in the United States for 3 to 4 months, immigration is well within their right to question why you continue to need this employee in the United States. So again, if you have an employee who absolutely has to leave, make sure that they are able to provide good supporting documentation of why they need to be working outside of the country for more than 30 days, 45 days at max, but don't just let them go away for 3 to 6 months because you authorized it without having good reason. Okay? If anybody has questions, you should be able to just ask them as well. I don't think we have anybody on mute, so whatever your preference is, feel free to ask any questions you may have. Right, I'm not seeing anything else on chat, and we are at 1 p.m. Again, I want to be respectful of everybody's time, so I I don't see anything else on chat. So if no one has any other questions, I think we will end the webinar for today. If you have any questions as follow-ups, like I said, you have my phone number as well as my email address. Feel free to give me a call, and either Eileen or I are happy to help you through any part of this as we go along. Let's see. Please send the PowerPoint. Yes, we will add some permission restrictions to this, but yes, we will send the PowerPoint. Any estimation on when EB1 would become current, that again depends on your country of birth. The categories that are backlogged currently are India and China born. I don't know when that's going to become current. That's something the State Department controls. I suspect something like the next 2 years, maybe would be current. You can still file your I-140. You just wouldn't be able to file for adjustment of status for EB1 or EB2 and IW. Same situation. You can file the I-140. I-140 belongs to you. You would not be able to file the following adjustment of status application. All right. Okay. Thank you very much for joining us. We please expect to receive. We'll have a recording of this webinar on the Buckwalter website. We will also add some sharing restrictions and protections to the PowerPoint before we share that, but you should expect to have that by the end of this week. All right, sorry, just seeing. Thank you. Bye-bye.